Hello, my name is Chris and welcome to our When Land Meets the Sea podcast, a coastal mini-series by Davitt Jones Bold. On this podcast, Richard and Lizzie take a road trip around the coast of England and Wales and visit some of the most significant cases and legal issues relevant to the coast. UK coastal towns are some of the best places in the world to be, but they also face major challenges, faring disproportionately worse than inland towns and cities for health, education, socioeconomics, crime, and more. Through this group, we are working to change that. For example, we recently worked with the government to get coastal communities added to the list of mayor competencies under the English Devolution and Community Empowerment Act 2026. We've also developed a framework for coastal placemaking and stewardship, which you can download for free at www.djblaw.co.uk/blue-horizons. Enjoy the podcast.
Hi, Richard.
Hello, Lizzie.
Hello. We're back for another episode on the coast. Well, sort of on the coast this time. We're actually going to the River Thames.
The tidal part, though.
There we go. We're going to be talking all about mooring and primarily adverse possession cases. And there's a couple of cases around this based on the Thames. So do you want to start us off?
Yeah, shall I give you the background? A little bit of a couple of minutes on adverse possession.
Yes,
and
please.
What you need. Yeah, generally adverse possession is it requires the paper owner to be dispossessed or discontinues possession for the relevant time period. And you have to have factual possession, a corpus possessionis, Lizzie, a body of possession, and an intention to possess the land, animus possidendi, as they say, an intention to exclude all others, including the paper owner. And if your claim arose when the title to the land you're claiming against was unregistered, you can claim after 12 years. Or if your claim arose, you had 12 years prior to the 2002 Land Registration Act coming into force on October the 13th, 2003, because that was the 50th birthday of the then Chief Land Registrar, if you remember. And that's why it was brought on that day. You can claim after 12 years. You can claim if the land's registered and you're claiming post October 13th, 2003, you can claim after 10 years, but there's various defences. And if you can't show one or more of three types of claim, you're going to fail. It's much, much more difficult. I should also stress, as we're talking about the coast, for both registered and unregistered land claims, including post 2003, if it's foreshore between high and low watermark, then it's 60 years if it's crown foreshore. Not if most foreshore is by the Crown. There's a presumption that Attorney General in Chambers from 1854 that it's owned by the Crown. And that would include things like tidal rivers, which a large part of the Thames is.
So how much of the Thames is tidal?
Well, it goes quite a long way. That's sort of, if you take the Thames as starting where the Port of London Authority has, or jurisdiction, that's between Falmouth Point in Essex and Warden Point in Kent, a line drawn between the two. And it goes as far as Teddington Lock in West London, the tidal parts of the Thames, and the domain of the Port of London Authority. So it's right through London. It's still tidal. And basically, the riverbed, I'll give you some of the history of it. Historically, there was disputes galore between the Crown and the City of London, whoever owned the riverbed. So there was that piece of legislation that I'm sure you've heard of, the Thames Conservancy Act of 1857, which stated basically that the Thames Conservancy would own the riverbed. And they were basically taken over by the Port of London Authority in 1909. And the 1857 piece of legislation basically said if you've got ancient moorings that have been granted by the Crown, which were there prior to September the 29th, 1857, then you still had the exact rights, the same rights as previously. And the Port of London Authority Act of 1908 allows the Port of London Authority can sort of ask you to move. They can't stop navigation along the river because that's a common law right. But they could ask you to move your boats if, moored permanently, or give you a license that you have to pay for But if you got ancient moorings, that wouldn't be the case. And that's some of the background.
So do you want to tell us about some of these cases then that you've seen along the Thames?
No, some of I did know about them already because we've talked about them briefly in adverse possession courses. Going back to 2010, there was a case called Ashmore in the Port of London Authority in Ashmore. And it seems what had happened is Mr. Ashmore he had a flat-bottomed boat called the Atrato, and he just navigated up the River Thames sometime in June 1983, and just stopped there. Dropped anchor and tethered his moorings to some his boat, almost at a ship, to some mooring rings, and they would. So it was flat bottomed, and twice a day at low tide, it would be resting on the riverbed. And the background to it is the Port of London Authority was busy going through registration of the riverbed, and he objected to this. He sort of argued that I can claim adverse possession here. And in that case, the High Court basically decided that he could succeed. He wasn't just floating his boat, so to speak, on the riverbed. He was actually resting on the riverbed, and you don't have to have a degree of permanence to claim adverse possession. He successfully claimed, and that was the first of the cases. It's hard to reconcile with some of the others, but shall I go forward a few years from 2010?
Yes, please.
There was a case, Port of London Authority and Tower Bridge Yacht Company in Downings Roads, which is just downriver from Tower Bridge. It's quite a famous place, actually. It's 30 boats, I think, about 100 people altogether who are living there and have been for sort of many a year. And the case arose primarily because the Tower Bridge Yacht Company wanted to charge them for licenses. And they claimed several things. They claimed that they got ancient moorings. And the evidence for all but 3 of these boats, the Court of Appeal said that it's up to the Tower Bridge Yacht Company to show that you haven't got moorings that predate September the 29th, 1857. And they couldn't do that. They also said that you had a right to maintain the moorings like for like as well. Say all but 3 of these moorings couldn't be shown to have sort of been in existence, before 1857, if you like, or not to have been in existence before 1857. So 3 of them didn't, but the other 27 did have ancient moorings and couldn't be charged a license. So they succeeded, most of them, on that, but they also tried to claim that they've got adverse possession. There were mooring rods into the riverbed. And the mooring rods, well, unlike the Ashmore case, they weren't resting on the riverbed, they were just floating. And the court decided that wasn't sufficient for adverse possession. There was a case called Cooper and Albion Property in the Port of London Authority. Again, the authority owned the riverbed. Albion Properties owned the bank by the side of it. It's by Battersea Bridge. That's a particular one. Max Cooper is an artist, a sort of installation artist. And amongst his artworks in the early 1990s, he had a collection of barges that he placed there. If that's art, who knows? But in 2006, developers, Albion Property, wanted to develop the area, which necessitated them, removing these barges, this barge collection, and he claimed ancient moorings. And in that particular case, in spite of the court in the previous case saying that the burden would be on the Port of London Authority, he failed because there was no evidence of any infrastructure before 1857. There was no evidence of the Crown granting any rights prior to 1857. And a lot of the moorings seemed to be rather new as well, so he failed on his ancient moorings. He also failed on another ground, which is amazing, hasn't been discussed further, and that's that a navigable river can be a highway, and you can't claim adverse possession over highway. It's once a highway, always a highway. It's a case not involving the moorings or anything, but Crown and on the application of Smith, Cambridgeshire County Council, and the Land Registry. There is another one called Port of London Authority in Mendoza. The Isle of Wight Queen was there, or the White Queen, but spelt as in the Isle of Wight and not as in the colour. And since 1997, they'd been mooring on this land, and they claimed adverse possession as well. Again, they weren't on the riverbed, but they were just moored. And again, you have to have a factual possession and an intention to possess them. And the court on that particular occasion, or the upper tribunal, I think it was, said that you might have a sort of factual possession of the area, but you don't intend to possess. They said a casual observer wouldn't think necessarily that you're sort of occupying that land permanently, as opposed to just temporarily occupying it, or just navigating down the river. So that's it. There's been other cases involving it. The Grand Union Canal at Brentford as well. There was a case there, and various others involving moorings. At the end of the Grand Union Canal at Brent, tidal reach is also tidal. And so there you go, a bit about moorings.
Excellent. And I suppose that whilst we focused on the Thames, it applies to all kind of tidal.
It's a bit more difficult. I mean, obviously, it was amazing how many people actually live. So I always said in the River Thames. They don't live in the River Thames.
Well, some do.
They live in boats on the River Thames. So beyond Teddington Lock, I mean, there's been problems opposite. Recently, there's been cases this year opposite Hampton Court and Moseley. People living on the river, and that wasn't really categorised as coast. There's been other cases. There's a case on Horning in the Norfolk Broads. Do you know Horning?
I know Norfolk, not
The Horning Ferry Inn, quite a famous pub that I've been to a few times. And there they successfully claimed an easement to moor. This was obviously, it wasn't tidal. It was on the River Bure. That's the way you pronounce it, Bure. And it wasn't tidal, but they successfully claimed an easement attached to a hotel to moor, a case called P&S Platt and Crouch in 2004. So there's lots to be said about moorings. I might write a book on
it. Coming soon.
Yeah, for Christmas. But a Christmas market.
Well, thank you very much, Richard.
Thanks a lot, Lizzie.